Hi, this is the AO3 for self-defense. So this is what you need for an essay. You've got to put the 10 marks of AO1, see the previous video, and then you add the AO3 to your essay. So first of all, there are lots and lots of points you can talk about. This is not an exhaustive list. You may think of other good points, maybe criticise the cases more than I'm going to here. First of all, it's a full defence. This means there's an acquittal. Even if you kill, perhaps that is a little bit too generous if you kill in self-defense. Maybe a good reform would be for it to be a partial defense in a case of murder. So have it reduced to manslaughter. That might be fairer on the victim's family. It also ensures that a defendant takes a killing seriously. Equally, the fact that it's a full defense is a good thing because you are showing that the defendant is not a true criminal. They were defending themselves or someone else. They were trying to prevent a crime from happening, so they should not be treated as a criminal. Okay, the next point is that a householder can use up to grossly disproportionate force. I would question, what is this force? How much is grossly disproportionate? If we're saying up to grossly disproportionate, I think we're saying a householder can use disproportionate force. The jury decide on what this word or these words mean, and obviously that can then lead to inconsistency. In the case of any other crime where it's not a householder, you could talk about reasonable force. What is reasonable in the circumstances? Everyone finds themselves in different circumstances. Okay, self-defense covers others, which is wide, which is good, I think, because it means you can protect other people from harm. So I think that's a good thing. The next issue is, well, how can you preempt force? What if the defendant seriously injures somebody and they made a mistake? They were never actually going to be attacked and they wrongly preempted force. We're saying the defendant has a full defence. This issue of a mistake, as long as it's an honest mistake, even if it's unreasonable, the defendant will have a defence. So I think you can criticise the fact that a mistake only has to be honest. It doesn't have to be unreasonable. I think it's good that the law is limited. There's no defence if you make an intoxicated mistake about using self-defence. So we didn't allow Lippmann the defence, and rightly so. If you take LSD and make a mistake, he killed somebody. He should be accountable. He should be held responsible. It acts as a deterrent for people who voluntarily take drugs or get drunk and then commit a crime, wrongly thinking they needed to act in self-defence. The next issue, just going back to householders, is in reality, very few people are prosecuted. There's a media moral panic about the fact that burglars have more rights than householders. They don't. The law on self-defense works very well in practice. There are so few prosecutions of people who have injured burglars. And burglars do not have more rights than householders. Householders can use up to grossly disproportionate force. I think that's more than enough. Next issue is that a defendant may panic when using self-defense, yet the jury are trying to decide whether it was reasonable in the circumstances. Was it necessary? Was it proportionate? The jury is sitting there nicely and calmly in a courtroom, and they have to try and put themselves in the defendant's position at the time, which may be difficult to do. Okay, the issue of should the defendant's psychiatric condition be taken into account? What if the defendant is paranoid about being attacked? I can see both sides to this. Firstly, we should make allowances for a defendant who's not the so-called reasonable person, reasonable man. However, equally, if they act and use an excessive amount of force, somebody has been injured and there is a victim in all of this, and that needs to be considered. Law is all about justice. And finally, there are no current reform proposals. So to me, this suggests that Parliament are perfectly happy. They think the law is satisfactory. Personally, I think one idea would be to codify the law, and that's where you put the law all in one place. So at the moment, we've got the Criminal Law Act, we've got common law, we've got the Criminal Justice and Immigration Act. So let's just put the law in one place. Let's codify it and put common law and statute law together. So as I said at the beginning, not an exhaustive list. Maybe consider Clegg. Was Clegg wrongly decided? Perhaps given the context, IRA, a stolen car driving towards them, maybe he was right to shoot at them, even though he shot the backseat passenger. But just, think about, is the law satisfactory? Does it need reforming? And maybe consider some of the points that I have discussed.